Before a jury trial can begin, a jury must be selected, and it is often argued that picking a jury is one of the most important steps in the trial process. We are going to talk about the multi-step process of jury selection and review some research on how jury selection influences verdicts. Early juries were not designed to be neutral or unbiased, as they were comprised of a defendant's neighbors and acquaintances. However, modern juries are now intended to be impartial based on our Sixth Amendment. The Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Essentially, the goal of a jury is to protect the defendant, and the defendant is supposed to have the final say as to whether the trial will be held before a judge or a jury. Before we get into some of the specifics of juries, it is important to distinguish between a grand jury and a petite jury. A grand jury is a selection of jurors who will decide whether or not to indict or charge a suspect. Grand juries typically consist of 23 people, and the jurors may have jury duty for months at a time. Grand juries will work closely with the prosecutor, who will explain the law to the jurors. The jurors then have the power to view almost any kind of evidence they wish and to interrogate anyone they like. The procedure for grand jury hearings is very relaxed in order to allow the jurors as much flexibility as possible. Typically, the parties that appear before the grand jury do not have attorneys, and the rules of evidence allow much more evidence than is allowed at a criminal trial. Grand jury proceedings are held in strict confidence to encourage witnesses to speak freely, as well as to protect the suspect if the grand jury decides not to bring charges. A grand jury's decision is not the final step in a case. Prosecutors can use grand jury proceedings as test runs for trials and take a grand jury's decision very seriously. However, if the prosecutor strongly disagrees with their decision, they may ignore it and file charges anyways. Several grand juries have made major headlines in the past couple of years. Can you think of any of them? Well, in 2014, a grand jury in Austin, Texas, decided to indict Governor Rick Perry for allegedly overstepping his authority as governor. Also in 2014, a grand jury in Staten Island, New York, decided not to indict the officer involved in the chokehold death of Eric Garner, and a grand jury in Ferguson, Missouri, decided not to indict police officer Darren Wilson in the death of Michael Brown. The decision in Ferguson has actually raised the question of reform, as the way the grand jury worked in the Ferguson case was much more like a trial jury than a grand jury. This brings us to a petite jury, or a trial jury. A trial jury decides the guilt or innocence of a defendant during a public trial proceeding. Trial juries decide the facts of a case, at a formal trial, and usually consist of 6 to 12 people. If a juror is selected for trial, they will have to work every day of the trial, which could last a few days, several weeks, or even months. Trial court procedure is very strict and controlled entirely by the judge. Each party in a trial typically has an attorney. Unlike a grand jury, a trial jury usually has no say in what evidence they get to see. Evidence in trials are carefully chosen by each party's attorney and must adhere to a set of rules designed to ensure that the evidence is reliable. Trial juries rarely have the opportunity to ask questions. A trial jury's decision is final. Although a decision may be appealed, a trial jury's determination of the facts will hold throughout the entire appeal process. In other words, if a jury found a defendant guilty, even if they appeal the case, the jury's fact that they found him guilty will be upheld. Since the Supreme Court decision in Thompson v. Utah in 1898, federal criminal cases have been required to have 12 members. However, in 1970, the court ruled that criminal trials in state courts can use as few as 6 members. In the case Williams v. Florida, the court held that a 6-person felony jury did not violate the Sixth Amendment. However, it is important to note that research has consistently shown that jury decision-making ability decreases as the size of the jury decreases. For example, in criminal cases, jurors make more errors in acquitting the guilty and convicting the innocent as jury size decreases. They are also less likely to resist social pressure, less likely to contain members of a minority group, and less likely to spend time deliberating. Part of these results are due to the conformity bias, which posits that as groups increase in size, the greater likelihood that a dissenter will have at least one ally. Therefore, minorities in larger juries will be better able to resist social pressure. Based on some of the research available at the time, the court ruled in Bailu v. Georgia that a felony jury cannot have fewer than 6 members, as that is a violation of the Sixth Amendment. While we will be mostly talking about criminal trials in this module, I want to touch on the different voting requirements for civil and criminal cases. In case you aren't sure, civil cases usually involve private disputes between persons or organizations, while criminal cases involve an action that is considered to be an offense against the state or society as a whole. One of the main differences in civil and criminal cases is the burden of proof, which refers to the threshold that a party seeking to prove a fact in court must reach in order to have that fact legally established. For instance, in an effort to show a defendant's guilt, a district attorney must show that a defendant is guilty beyond a reasonable doubt in a criminal trial. As for civil cases, the burden of proof is clear and convincing evidence, or a preponderance of evidence. While it may sound higher, that is usually a lower standard than beyond a reasonable doubt. For that reason, it is more likely than not that the defendant will be found liable. As for voting, the rule of the land used to be that all verdicts had to be unanimous, but that changed in 1972 when the court ruled that state law permitted criminal defendants to be convicted by less than unanimous votes. So as it stands, if there are 6 jurors, then the verdict must be unanimous. However, depending on the state, if there are 12 members, the vote can be 11-1 or 10-2. For example, Oregon and Louisiana currently allow convictions on 10-2 verdicts. Interestingly, the court ruled that there was no significant difference between a unanimous jury and a jury voting by 10-2 or 11-1. I think both common sense and research tells us that that statement is false. And surely if we were in that position, we would want a unanimous verdict. It is important to note that some states have set standards that require unanimous verdicts in all cases. The last time this issue was visited was in 1979, but there was a push in 2014 to have the Supreme Court revisit it. The Sixth Amendment guarantees an impartial jury, but is it possible to ever have a truly impartial jury? Well, there are a couple of ways they try to reach as close to this standard as possible. First, a jury must be a representative cross-section of the community. Second, jurors that are chosen must be unbiased, that is, willing to make a decision about the case based on the evidence presented. In theory, this all sounds great, but research has consistently shown that jurors, and people in general, are typically unaware of their biases. In fact, research shows that the effects of stereotypic and dogmatic beliefs on behavior increase when people are pressured from factors such as time limitations, other jurors, exhaustion, or the need to incorporate complex information in order to make a sound decision. In addition to that, research also shows that when a difficult decision has to be made, say determining if someone is guilty or not, groups perform at the level of their average member, not the highest performing member. That is, the decision-making ability of a group is collectively lower than any one individual. What is usually referred to as jury selection is usually a process of deselection. The first step is to get a jury pool. Ideally, there would be a list of names and addresses of citizens in a particular geographical area who speak English, are over the age of 18, are mentally competent, and who have never been convicted of a felony. Since such a list does not exist and would need to be continually updated, the next best option is to go off voter registration lists. Some states add lists such as of licensed drivers or telephone directories or people receiving unemployment benefits. The inability to get a comprehensive list of all eligible potential jurors introduces the first layer of bias, as the lists often underrepresent poor people, African Americans, Hispanics, people who move frequently, and young adults who recently turned 18. Next, a random sample of potential jurors is selected from a jury pool, and everyone is sent a summons to appear at a specific time and place. This group of prospective jurors is called venire. Typically, the size of the venire depends on the case, where the case is tried, the rulings of the presiding judge, and the characteristics of the case. For a fairly routine case in a small town, lawyers may begin with a 30-person venire. In a high-profile case that received a lot of pretrial publicity, the venire may consist of more than 100 people. The trial in Florida of George Zimmerman started with a jury pool of 500. Former Penn State football coach Jerry Sandusky began with a jury pool of 600. Most recently, the case against the Aurora theater shooter in Colorado, James Holmes, began with a jury pool of 5,000. Yep, you heard that right. That jury pool stands to be the biggest venire in history. The final stage in the process of jury selection is voir dire. The function of this step is to give the defense and prosecution the opportunity to inquire into, or have the trial judge inquire into, any bias or prejudice that would make it inappropriate for any potential juror to serve on the jury. This aspect is sort of a pre-trial interview and provides attorneys with an opportunity to remove or challenge potential jurors. They have two types of challenges that they can use: challenges for cause and peremptory challenges. When a lawyer makes a challenge for cause, they are basically saying that for some reason they think this potential juror will be unable to render an impartial verdict based solely on the evidence and law. An attorney may say this is due to not meeting the statutory requirements to serve, or due to a bias or prejudice. The number of these challenges are unlimited, but a judge can disagree to dismissing a potential juror. If a judge refuses to dismiss a potential juror, the lawyer must decide whether or not to use a peremptory challenge. With this type of challenge, a lawyer can dismiss a juror without giving a reason and without approval from the judge. Each attorney is allotted a small number of these challenges, with the defense typically getting a greater number. In the O.J. Simpson trial, the prosecution was awarded 20 peremptory challenges. Some other important information about voir dire is the fact that the law forbids attorneys to discriminate against cognizable groups on the basis of religion, race, or gender. However, there are ways for attorneys to get around this, as they can use a peremptory challenge and if a judge asks if it is related to religion, race, or gender, they can just provide another reason. Warning: in the next couple of slides, there will be quotes from various attorneys that are insensitive, racist, sexist, and altogether offensive. Many critics of the jury system argue that lawyers essentially use their challenges to stack juries. Realistically, this makes sense considering attorneys want jurors that are going to favor their side of the case. When preparing for a case, a lawyer must attempt to figure out which potential jurors will be the most favorable to their side. At this point, they do not have much to go on. They may rely on stereotypes or physical appearances, such as gender or tattoos. There may be information from a written questionnaire asking a broad range of questions about likes and dislikes, political attitudes, hobbies, etc. They can also ask questions during the voir dire that will help them determine whether a person will be beneficial to their case or not. Based on those interactions, they may ask questions such as, was that juror well-spoken? Did they seem interested in what the defense had to say? Does that person seem like they would be a leader or a follower? No matter what they rely on for information, at the end of the day, an attorney has no idea how a potential juror will respond to evidence in their case. To guide their decision-making, some lawyers have developed crude shortcuts for selecting jurors. Manuals for trial attorneys are full of advice on how to pick jurors, and much of this advice relies on simplistic stereotypes about ethnic and occupational groups. This is a quote from Jerry Spence's book, Win Your Case: How to Present, Persuade, and Prevail. Every place, every time. Jerry is a semi-retired trial lawyer in Wyoming, and as of 2014, had never lost a criminal case either as a prosecutor or a defense attorney. In his book, he stated, "Women are more punitive than men by a score of about 5 to 1. There's a reason for that. Women always had to toe the line. Women are splendid jurors for the prosecution in rape and baby cases. As a defense attorney, I prefer men because men had more experience hell-raising and were more forgiving of it. Obese people are desirable because they lack self-control and don't demand as much law-abiding discipline from others. Yuppies are the worst because they fear crime, love property, and haven't suffered enough to be sympathetic to the accused."
A competent, fair, and impartial jury. Well, that's ridiculous. You're there to win. And in order to win, and the defense is there to win too, and the only way you're going to do your best is to get jurors that are as unfair and more likely to convict than anybody else in that room. Let's face it again. There's the blacks from the low-income areas are less likely to convict. And as a result, you don't want those people on your jury. And it may appear as if you're being racist or whatnot, but again, you're just being realistic. You're just trying to win the case. You don't want smart people, because smart people will analyze the hell out of your case. They have a higher standard. They hold you up to a higher standard. They hold the courts up to a higher standard because they're intelligent people. They take those words reasonable doubt, and they actually try to think about them.
That was Jack McMahon, who was the district attorney in Philadelphia at the time of the video. The video was dispersed as training for other district attorneys who wished to keep black jurors out of their jury pool without violating the 1986 U.S. Supreme Court ruling in Batson v. Kentucky that a defendant deserves a new trial if it can be proved that jurors were excluded on the grounds of race. He made the following comment in an article entitled "Fear of a Black Jury," which was published in Harper's Magazine in July 2000. He stated, "Let's face it, blacks from low-income areas are less likely to convict. There is a resentment of law enforcement. There's a resentment of authority, and as a result, you don't want those people on your jury. And it may appear as if you're being racist or whatnot, but you are just being realistic." He also stated, black women are very bad. There's an antagonism. I guess maybe because they're downtrodden in two respects. They're women and they're blacks. And they want to take it out on somebody. And you don't want it to be you. He also stated that leading questions for a juror you want. When you have a juror you obviously like, you lead them. You don't say, ma'am, would your having been a victim of a crime have any effect on you? Because she may say yes, and that's not the answer you want. So you say, ma'am, you indicated that you were robbed at knife point. Now, of course, that wouldn't have any effect in deciding whether this guy is innocent or guilty, because that has nothing to do with your incident, right? And to lead questions for a juror you don't want, for a juror you don't want, you would say, well, sir, the fact that your brother was killed in a violent crime, that terrible trauma that happened to you might affect you in deciding whether this guy is guilty or not, right? Right? He also made the following comments about intelligent jurors. If you don't want smart people, I wish you could ask everyone's IQ. If you could know their IQ, you could pick a great jury. You don't want smart people because smart people will analyze the hell out of your case. They take those words, reasonable doubt, and actually try to think about them. You want people who are going to say, if they say she did it, she did it. You don't want the town idiot either, but you want something in the middle. And on social class, if you take well-dressed, middle-class people, you're going to do well. It's that simple. Look at their dress, how they act. If the guy is reading Karl Marx, you don't want him. Use your common sense. If the guy is reading a spy book or a police book, you're gonna like that person because he's more philosophically attuned to conservative aspects. Another way that attorneys attempt to slant the jury towards their side is by using scientific jury selection. This refers to the application of behavioral and social scientific principles to the selection of jurors most sympathetic to a particular side in a court case. The first attempt at so-called scientific jury selection occurred in 1972 during the Harrisburg 7 case in Pennsylvania. In that case, a team of researchers worked to help attorneys defend 7 Catholic anti-Vietnam War activists who were accused of pouring blood on draft records, conspiring to blow up underground electrical systems in D.C., and plotting to kidnap the Secretary of State. The researchers interviewed more than 800 residents, gathered demographic information, and measured attitudes relevant to the trial, such as attitude towards the Vietnam War. From this information, the researchers constructed profiles of jurors who were likely to be pro-defense or pro-prosecution. They predicted that the ideal prosecution juror would be a Republican businessman who identified himself as a Presbyterian, Methodist, or fundamentalist Christian, and who belonged to a local civic organization. On the other hand, they predicted the ideal defense juror would be a female Democrat with no religious preference and a white-collar or skilled blue-collar job. It is difficult to know whether this research helped, but the trial did end up in a hung jury. Another high-profile case that has been regarded as a triumph of jury selection was the 1995 murder trial of O.J. Simpson. Both sides originally hired jury consultants and relied on individual and group interviews. They also had all potential jurors fill out juror questionnaires, which included 294 questions and a 79-page survey. Some of the questions included, have you ever worked in a laboratory or in any medical research or testing facility? Have you ever worked in the entertainment industry? What is the last level of education you completed? While in school, what was your favorite subject, least favorite subject? Have you ever seen O.J. as he appeared in movies such as Roots or Naked Gun 2.5? And have you ever dated a person of a different race? And what is your political affiliation? Based on the information collected, both sides of the case concluded that African American women would be the group least likely to convict Simpson. In fact, research found that African American women were more likely, 3 times more likely, in fact, as black men, to believe that that Simpson was innocent. This finding directly contradicted the prosecution's intuition that women would be more likely to convict a domestic abuser. Research also found that both female and male African American jurors were more likely to be receptive to the defense's theme, that corrupt police officers planted the evidence. Lastly, research showed that well-educated jurors were much more likely to trust the incriminating evidence from the prosecution, such as the DNA evidence. The following is a breakdown of the jury pool. It started with 250, and the final voting 12 included 8 African American women, 2 white women, 1 African American man, and 1 Latino man. In this graph, you can see how the racial compositions changed throughout each process of jury selection. It is also important to note that 6 jurors, 1 replacement, and 2 alternatives were removed during the trial. It is also important to note that the district attorney filed the charges in downtown LA, where the racial composition of the jury was arguably different than it would have been if the charges had been filed where the crime actually occurred, which was Santa Monica. After listening to evidence and testimony for 8 months, it took the jury less than 4 hours to reach a verdict of not guilty on all charges. Some final stats about the jury: they were all 12 were Democrats. Only 2 were college graduates. None regularly read a newspaper. 5 had family members who had a negative experience with the police. 5 thought that domestic violence is at times justified. And 9 of the 12 jurors thought it was unlikely that O.J. could murder because he was a star football player. Obviously, we know the result of that trial. And in a post-trial interview, one of the jurors stated, "I didn't understand the DNA stuff at all. To me, it was just a waste of time. It was way out there and carried absolutely no weight to me." As you can see, even though the supposed goal is to have an unbiased jury, there is a lot that goes into jury selection that works against the defendant before the trial even starts. In fact, famed defense attorney Clarence Darrow said, "Never forget, almost every case has been won or lost when the jury is sworn." Some other interesting jury questionnaires include the questionnaires for the Michael Jackson case and Kobe Bryant case. In the Michael Jackson child molestation case, some of the questions asked if the potential juror had ever worked or volunteered for a child advocacy group, if they ever had anyone close to them be diagnosed with cancer, or if they had ever known anyone who had been accused of inappropriate sexual behavior. As for the Kobe Bryant sexual assault case, it asked questions such as, would you favor the side that had law enforcement officers as witnesses? Or what are your feelings about sexual assault laws in Colorado? If you are interested in some more looking at these questions, I have uploaded the jury questionnaires for both of these cases, as well as the Aaron Hernandez case, to Canvas. So how long does it typically take to select a jury? Well, on average, typically an hour in civil trials, 2 hours in criminal trials. In a New York study, it showed that it could range depending on whether it was supervised or unsupervised. And in one jurisdiction, it lasted a total of 18 minutes, where it lasted for 49 days for the Hillside Strangler and 41 days for the O.J. Simpson criminal trial. Here is a chart of how long the process took for several other famous cases. As you can see, it took 23 days for Scott Peterson, and they started with a pool of 200. They also had a questionnaire in that case that was quite a bit shorter than the O.J. Simpson jury questionnaire. Martha Stewart's voir dire lasted 38 days, and they had a 40-page questionnaire. Let's move away from jury selection and talk about some of the factors that can influence jury decision-making. One major source of bias is pre-trial publicity. As one could imagine, jurors are unlikely to shed their prejudices and preconceptions about a case when they walk through the courtroom doors. In a high-profile case, there is likely to be coverage of the case before jury selection even begins. Most of the time, there is a pro-prosecution slant to the coverage. In other words, a defendant is likely to have already lost some of their presumed innocence. Pretrial publicity often involves information that would not be admissible at trial, and research has consistently shown that negative pretrial publicity made jurors significantly more likely to find the defendant guilty. Some potential remedies include the judge issuing a continuance or expanding the voir dire. A judge can also give judicial instructions before a jury deliberates, but research has shown that to be largely ineffective. Some other options are to import jurors from other counties or states, change the venue, or ask about pretrial publicity in the jury questionnaire. It is important to note that judges are not allowed to use gag orders, as it is an unconstitutional restraint on the press. Jurors are not only told to ignore pretrial publicity about a crime, they are also told to ignore other types of inadmissible evidence, such as information that may be prejudicial. This information may come from judges or attorneys. You have most likely seen in movies or TV shows when one attorney calls out "objection" in response to a question or statement by the opposing side, and the judge either sustains or overrules it. If the judge sustains the objection, he or she will tell the jury to disregard the inadmissible evidence. Basically, the jury is just supposed to forget whatever they heard and not let it influence them. As you are most likely thinking to yourself, how is it possible to just make yourself forget something you just heard? Well, research has suggested that you can't, and that the judge's instructions to disregard the information actually has the opposite effect. It seems to cause the jurors to give the information extra weight. In a meta-analysis of 48 studies, researchers found that inadmissible evidence has a reliable effect on verdicts. So what about these jury instructions? Well, research on jury instructions have shown that comprehension rates range between 13 to 73%. And they've also found that even after receiving instructions on the definitions of crimes, jurors continue to apply their own pre-existing understandings of offenses. For example, jurors may subject their compliance with legal rules to their personal sense of justice. As you can see from this chart, there are many factors that relate to a hung jury and why. While we have definitely highlighted some glaring examples of how the jury selection and jury decision-making process can go awry, it is important to note that for the most part, most jurors are imbued with common sense and take their role very seriously. There is, however, support for reform. Some minor changes in the way trials are conducted can go a long way in assisting juries to better understand proceedings and to achieve better and fairer results. One way is to help jurors understand complex jury instructions by simplifying the instructions or providing better definitions of the terms used in those instructions. Changes can also be made to help jurors better understand the evidence put before them. Allowing jurors to ask questions and take notes has been demonstrated to increase their understanding and recall of the facts. Finally, using court-appointed experts to assist and educate jurors faced with technical or complex evidence would lessen juror confusion caused by biased, partisan expert witnesses.